by Deputy AG, Deputy Attorney General, Dr. Justice Sremsai. And it reads as follows. I can confirm that the Chief Justice, Her Ladyship, Justice Gertrude Tokonu, has filed another court case, this time at the ECOWAS Community Court in Abuja, Nigeria, against the Republic. Now, what types of cases, you ask, can the ECOWAS court hear? Well, the ECOWAS court has a broad mandate and hears several categories of cases, including interpretation and application of ECOWAS legal instruments, disputes between ECOWAS and its employees. You've also got liability cases. But what we are particularly concerned about is human rights violations. And we believe that's what the now suspended CJ's issues are hinged on. Now, since a 2005 protocol amendment, the court has jurisdiction to hear cases alleging human rights violations by member states. Individuals can bring claims directly, and the court does not require that all local remedies be exhausted before filing. And I think that's very instrumental for many who ask the fundamental questions. Why are we not seeing through our processes on home soil before we elevate the conversation? Again, individuals can bring claims directly, and the court does not require that all local remedies be exhausted before filing. Now, the ECOWAS court has explicit jurisdiction over alleged human rights violations committed by member states, of which, of course, the Republic of Ghana is a member state. Now, this includes cases where an individual claims that their human rights, as protected by regional or international law, have been violated by a government action or omission. The court can hear such cases even if domestic legal remedies have not been fully exhausted, making it accessible for individuals seeking justice beyond their national courts.
The best in the morning is on 92.7 Sunrise on 3 FM.
Now, with that small foundation on the locus of the ECOWAS Court of Justice, let's get onto the phone lines and speak with private legal practitioner Christian Malmhesi, and we'll be talking through this latest development, also highlighting some key issues that have happened so far. Counsel, good morning. Hope you're doing well.
Good morning, my dear lady. I'm fine. Thanks for having me this morning.
Thank you so much for making the time for us. Now, we caught wind of this court action as advanced by now suspended CJ via an ex-post from the Deputy Attorney General. We know that the processes on home soil are still ongoing, and that the ECOWAS Court of Justice doesn't necessarily require that the processes domestically here in Ghana be completed before suspended CJ seeks some remedies in that particular court. But seeing how the case has traveled so far, would you consider an action like that premature based on the context of what we know now?
Yes. The point is that if a legal remedy is available to someone, that person need not wait to exhaust other means. Once the ECOWAS Court of Human Rights can entertain that particular application by way of its jurisdiction being invoked, that suffices. It only stands to wisdom that yes, you have other pending matters, and by way of that, one could exhaust that before moving on to mount another. But by way of knowledge, it can differ. And that is what I've just submitted preliminary, that by way of knowledge, once the court can entertain it, irrespective of whether she's at the High Court, she's at the Supreme Court by way of the review jurisdiction of the Supreme Court. Nothing but from further mounting other fights in this contest, what she has just filed at the ECOWAS Court of Human Rights, as the learned Deputy Attorney General indicates.
Certainly. But a lot has still been said about this action that now suspended CJ has taken. And as you clearly have stated, and as we do know, the processes at the national court, so in the Ghana courts, must not be exhausted or do not have to be exhausted before this other action is taken. But would you say that it is prudent to do so, or would you consider it still premature, just as by way of an opinion?
When it comes to opinion, and in this matter, opinion would be by way of advice. Yes,
right.
There's a blur line. It would be by way of advice, and it would be by way of me seeking to advise the lawyers of the learned Chief Justice as to what they ought to have done and what they ought not to have done, which I will not shudder to. But what I can say is that I use a typical example of wisdom and knowledge, that once they have not exhausted all the processes, all the forums here, because I know they have one at the High Court, and I know they have invoked the review jurisdiction of the Supreme Court.
That's right.
Which is yet to be exhausted. Now, by way of knowledge, which it delves into the ECOWAS area. The ECOWAS area, if you look at the protocols, nowhere does it indicate that the domestic front needs to be exhausted. It
That's right.
indicates that where there is a human rights violation, an individual can bring an action against an institution of an ECOWAS state, and it lists what an ECOWAS state is. That's under Article 6. It lists a number of them. So in this case, it will be the authority of heads of state and government. So it will be the government of Ghana that she would be dragging there, or as by way of what we now know, she has dragged there. So once in knowledge, it allows her to take that step. She's exhausting it. She's throwing everything she has. She's throwing everything she has in her corner to make her game plan work. Much ado with nothing. So let me throw all the darts. The one that will stick for me, and she believes that one of them will stick. So,
and counsel, that's what you
it doesn't prevent her, but by way of wisdom,
right,
one would say exhaust the internal processes, and then if you are seeking international jurisdiction, that would also suffice. But hey, she wants to have all of them running concurrently,
right,
and nobody can impede that.
Now, I was going to ask, is that what you infer from her action so far, that she is going to, use anything and everything in her arsenal to also seek some sort of justice for herself? And as you mentioned, whatever sticks, then, that is the way forward. But so far, as this case has traveled, have you spotted any unconstitutionality so far in this process? That's been a big bone of contention, and for supporters of now suspended CJ Tokonu, it's been drummed time after time that something untoward has happened so far as Article 146 is concerned. If I recall, the last time we spoke on this matter, you say that the processes had been conducted so far in accordance with Article 146. Is there anything that has changed for you as the process has carried on? I'm not sure that we've spoken since CJ Tokonu suspended, took to the press and organized that press conference.
Yes, we are not spoken. CJ Tokono's press conference, she divulged things contrary to Article 1468. And in Article 1468, matters of the proceedings are to be heard in camera, and they are to be held in secrecy, to protect the independence and integrity of the judiciary, and also the office of the Chief Justice. That was elucidated by His Lordship Justice Dateban, in the Tum versus Attorney General case. That and also in the Ghana Bar Association versus Attorney General. There are a number of authorities that speaks to Article 1468. Now, the learned Chief Justice coming to put all of that out was very unconstitutional. But I believe she knows about that, and
right,
and she decided to do that all together, probably to appeal to emotions and also let people know what is happening in there, even though what she did was unconstitutional, appealing to emotions of persons. Now, one would say that she could have waited for the process to end and bring Seturara to quash the decision,
right,
citing issues of unfair trial. Citing that, she had issues of unfair trial, contrary to Article 19 of the 1992 Constitution. But where the process is ongoing and it is to be heard in camera, now the Supreme Court decision was that the supplementary affidavit, the whole essence of it or the substance of it, is divulging in-camera proceedings to them. And they declined that invitation because once they are inclined to that invitation, it means that they are participating in an illegality, which would contravene Article 1468 and the cases that I had mentioned. So they declined that invitation. Hence, it was struck out. Now, she has sought for review. And I do not know whether she has sensed the possible outcome of it, because, yes, as lawyers and judges, definitely, we sometimes anticipate the probable outcome of legal arguments pending ruling.
Right.
Yes, so probably in that contemplation, she decided to go to the Human Rights Court of ECOWAS,
right,
to invoke that jurisdiction and all of that, to also try and take a dart and see whether it will hold.
It will hold. Now let's stick with that, and let's play in the terrain of hypotheticals very briefly. What are the implications for judicial independence if the ECOWAS court rules in favor of the Chief Justice, for example?
Oh, once we have signed to the Treaty of ECOWAS, it takes away issues of judicial independence, because that is what we have signed to. It is more like the Human Rights Court in Europe, where it adjudicates over human rights violations. You realize that at the time, UK was part of Europe, and these European courts subverted the judicial independence. So it meant that their decisions were not absolute until they had the Brexit, and that dealt with that situation.
Indeed.
So once we have consented by way of assenting to the ECOWAS protocol to have the ECOWAS court, it has jurisdiction. If you look at Shatawale at a point in time brought an action against the Republic of Ghana at the ECOWAS court that his human rights has been violated vis-a-vis a gaming deal that he had contracted. Now, in that particular case, he didn't clearly delineate or point out which company, amongst other flaws in his case. The learned attorney general at the time indicated that the court did not have jurisdiction to hear the matter, citing the question that you just posed to me, that in respect of judicial independence. Now, the court dismissed Shatawale's case, but indicated that once Ghana has appended its signature, Ghana is subservient to the jurisdiction of the ECOWAS, the Human Rights Court of ECOWAS, and that the only reason why Shatawale's case failed is that he didn't have a good case before the court. So once we have signed to the Treaty of ECOWAS, we remain under the jurisdiction, the territorial jurisdiction of it.
Certainly, and very interesting thoughts there, Counsel. And thank you also for giving us some much needed education on this particular instance. Now, I think then you've possibly...
Can I add this
Indeed.
For your next question?
Yes.
I would want to. It says that I'm trying to get... now, if there is this case of Bakari, Sari, and two others versus the Republic of Mali, where it indicated that the competence of the court to adjudicate over cases that emanate from ECOWAS jurisdiction, once the treaty has been signed. So just to further frame up that position.
Certainly. Christian, thank you so much for that. I was going to say, then, I'm not too sure if you've answered my next question, but I'll ask it anyways, and then you can put some more flesh on the bone. So, can an ECOWAS court's decision override or influence ongoing proceedings in Ghana's domestic courts?
Yes. It is a complex question and answer at the same time. Yes, because once we have, the problem is, to answer the first point is, has the Supreme Court determined the case to its finality? No, because the court at ECOWAS would look at whether the Supreme Court misconducted itself. That remains a very important case. If you look at the case of Woyome, where he took the case to the Human Rights Court, the African Human Rights Court at Tanzania, the court indicated that the Supreme Court had not misconducted itself and concluded that his human rights have not been violated. You understand? So that's why I said it's a complex mix. Now, in this situation, I have cited Shatawale, I have cited this Woyume one, and then the jurisdiction one with this Bakari matter. Now, the conclusion is, can we infer that the domestic fora, so the fora will be the Supreme Court and the High Court, have they misconducted themselves in dealing with the human rights matters of Mrs. Tokono EJ. If that question can be answered in the affirmative or negative, it will determine the case at the ECOWAS court. But if that matter, if the Supreme Court, number one, has not concluded the matter by way of review jurisdiction, for the court to infer whether the court here has misconducted itself by infringing on the human rights of Mrs. Tokono, then that will also be to her detriment, because the court is going to look at the processes, the decisions of the court vis-a-vis our constitution, and come up with a pronouncement. So, to answer your question, I believe all that analysis that I have done will fit into, because I cannot give you a hook and line sinker answer.
Right.
But the explanations that I have given would show the conclusion as to whether the ECOWAS court decision will be final. It will be final based upon the determinations of the decisions of the court here as to whether it has misconducted itself by way of infringing on the human rights of the learned Chief Justice. If it has not done that, then the learned Chief Justice has a clean case at the ECOWAS court. If the court has indeed violated, or let me say, if the court, to be the High Court and then the Supreme Court, if the court have violated her human rights, then she would have a field day at the ECOWAS court. So these are legal technicalities that will play out at the ECOWAS court.
Absolutely.
Her case in simplicity.
Absolutely, and it's one that we certainly keep a keen eye on. Counsel, thank you so much for your time this morning. Always a pleasure, and thank you for
having me,
giving us some extra context in this particular matter. But let me come back in studio, and I have Victor Adawudu, private legal practitioner, also a member. I beg your pardon. Let's correct that immediately. Sir, hello, good morning.
Good morning.
Which name have I gotten wrong?
My name is Theophilus Jimega Jr.
Wrong number, as we say. Mr. Theophilus Jimega Jr. Jimega Jr. I believe you're also a private legal practitioner.
That is so, and an engineer.
And an engineer, and a member of the National Democratic Congress.
Communication team.
Communication team.
Yeah.
Pleasure to have you here with us this morning. Hope you're doing well.
Appreciate it. I'm doing well. It's been a wet morning, a pleasant one.
Are you enjoying the cooler temperatures?
Yes, I enjoy it. I love walking in a drizzle. So.
Really?
Yes.
Are there health benefits to that?
It allows you to think faster.
Most certainly. But again, you're warmly welcome to 3FM Sunrise on 3FM 92.7. Now, we've been talking about the latest twists in the events as far as the removal of suspended CJ Gertrude Tokono is concerned. Yesterday, by way of an ex-post, we saw from the Deputy Attorney General, Dr. Justice Shamsai. He's let us know, the good people of Ghana know, that now suspended CJ has taken this matter to the ECOWAS Court of Justice in Nigeria. And we know that they do have that jurisdiction to look at matters like this because we are a member, a member state of ECOWAS. We've been seeking this morning to truly understand what kind of implications that could have on what is happening on home soil. So Theophilus, please weigh in on that for us.
Good morning to your listeners. It's a pleasure having me here. One, I am surprised at where the suspended Chief Justice has headed to. Reason being that before the ECOWAS court will assume jurisdiction and will say we need to hear this matter properly, they will be asking themselves, have you exhausted all domestic remedies?
Why would they ask that when that is not a requirement before an individual actually goes to the ECOWAS Court of Justice?
It's a requirement. It's a requirement. They might not ask that, you see, except there are barriers in your way in the country where you cannot seek justice. if you're able to prove that there are those barriers, for example, you are being chased, you are likely to be killed if you appear, and that you can move on to say, so there's no way I can get myself to that court and get a remedy or justice out of the domestic court. Now, until you're able to do that, they will ask you, once you have not been able to remove those, you have not been able to exhaust all the remedies. Even in Ghana, let me give you an example.
Right.
If you have a grievance against TV3 and you've not followed 3FM or TV3 or Media General's internal disciplinary procedures, you have not exhausted it, and you go to court, the court will ask you to go back and exhaust your internal procedures before you come to them. Except you are able to prove that the people who will help me to exhaust are the ones accusing me, are the ones I have the matters with, so there's no way I'll get justice. That is it. In this current situation, fast forward to the suspended Chief Justice's case, the judges don't have anything against her. It is an individual or a group of individuals that have petitioned. You have been to the Supreme Court. You were given a hearing. You have been to the Supreme Court yourself. 2 other applications were filed on your behalf, and they were also given hearing. You are currently even at the High Court seeking an enforcement of your fundamental human right. And indeed, our Constitution, the whole of Chapter 5, is on human rights. That has not been exhausted. And you go to ECOWAS court, I can tell you, it's likely to be thrown out.
Would you then say that this action on the part of the suspended CJ is simply premature?
If you pay attention to what the Deputy Attorney General posted, she said, in effect, by her suspension, the president has, in effect, removed her from office. That's what we call constructive dismissal or termination, sort of. Now, what came to my mind is, what went on at the proceedings? Is that way that she has sort of come to the conclusion that with what is going on at the proceedings, I am gone. Now, if that is not the situation, then I think that having gone there is premature. There was the Nigerian Chief Justice who was removed under General Buhari. When he was removed, the court is in Abuja. He was in Abuja. The ECOWAS court was in Abuja. Is in Abuja. He was in Abuja. He didn't go to that court.
Where did he go?
He decided to fight it in the Nigerian court. And I think recently he won. Even years after Buhari is gone, recently he won. He could have walked just to the ECOWAS court, but he said, let me use the internal one. Now we have our own Madam Isaba Gertrude Saki Tokono saying that I will fly to Abuja to seek justice there. I mean, I want you to look at the optics in that regard. So,
but just pausing you there very quickly, Theophilos, about the optics. On one side of the coin, one might say that, well, this is a Chief Justice who has addressed the press and made known to all of us that that her human rights have been violated, and she has cited some reasons for which she believes so. If there are many avenues available to her and processes can run concurrently in the strictest, sense of the term, what is her fault here in seeking to try as many avenues as possible? Yes, you do make that clear point to us that even the ECOWAS Court of Justice will be seeking to find out if these processes are exhausted on home soil. Why, not wait for that? That's something that you mentioned will probably be the order of the day. But for those who say she's seeking justice wherever she can, is she really in the wrong for that?
Yes. There is a theory in law. The law does not deal with trifles. The law does not deal with very, very minute things. Otherwise, life will become incredibly slow and incurably slow. For example, you cannot go to the police station right now to say, I hit my foot on the rock, so help me. I cut my finger whilst cutting my nails, help me. I overcut my nails, help me. I mean, can you imagine what would have happened if everybody would do that? Then there's also something called forum shopping. You cannot be looking for this forum. I go to this court. I'm not okay. I want to go to this court. I feel this court to do. You cannot go forum shopping for the forum to see which one will really listen to you. Now, then there's also the theory that if a procedure is provided for something to be done, only that procedure has to be followed. If a procedure is provided for you to air your grievance, Only that procedure you need to follow. No other procedure. The procedure is clear. Go for the administrative hearing, which is ongoing at the moment. If that is not okay with you, go to the Human Rights Court. Remember, all the things she has catalogued, she has gone to court over it. But then, you would have known that anybody who comes to equity must come with clean hands. Or when you come to equity, you must be willing to do equity. The Constitution says that all proceedings under Article 146 are to be held in camera. And you decide to hold a press conference and tell us everything that is happening. That alone is also enough grounds for somebody to petition for her removal.
You say she's acting in contempt? Do you think somebody could then refer this to the High Court?
I will not go for contempt. I'll go for the fact that she took an oath to protect, defend, and preserve the Constitution. And what she did was not defending the Constitution. It was unconstitutional. So the oath that she has taken, if breaching a constitutional oath can get the president removed, then in same reasoning, it can get the Chief Justice removed. That's the sort of thing I will not go for contempt. No. Those are things others, you can close your eyes to contempt and leave it. But this is a constitutional infringement. So for her to have gone contrary, you see, before the committee was formed, or before her suspension, you would have heard Ajay-Chum all over the place.
That's right.
Yes. The Ajay-Chum case stated that one of the things that came in was that the petition was made public, which it shouldn't have done. The former president, Nana Akufo-Addo, also said that Professor Azar Asari has also published his petition. So that would not that was one of the reasons why the petition was thrown out. Then how come you, who is supposed to be the best, to know the law is in your bosom, you are supposed to be the creme de la creme of all the judges we have. You are the topmost judge that we have. So I can presume with all certainty that you know the law better than all the others who are into the law field. How will you do that? And you know that the Chief Justice also she has lawyers that are working with her.
Indeed.
Yes, they would have given counsel. I don't know what counsel they gave her. You see, and one of her famous quotes is what? The law
is the law.
Is the law. So why won't she allow the law to be the law?
Very interesting perspectives here from Theophilus. Time check. It is some 10 minutes past the hour of 9. You're still tuned in to 3FM Sunrise on 3FM 92.7. We're talking about the latest twist in the saga concerning now suspended Chief Justice Gertrude Torkornoo. We've been talking about what the process is as filed in the ECOWAS Court of Justice could mean for processes that are currently ongoing on home soil. And I'm talking about that removal process. And Theophilus, one theme that has been running through, especially on the part of supporters of suspended CJ, is that there has been some unconstitutionality as far as Article 146 is concerned. Has that come to light? Do you think that has been that argument has been properly cemented? Do you see where any anomalies have been cited?
No. If you recall, about a month ago, the GBA issued a statement, not a resolution, issued a statement to say so far the procedure has been good.
That was their initial statement,
yes,
I recall.
Yes, that was the initial statement. The resolution, you know, the bashing it received.
That's right.
Yes, and how lawyers, other law groups, including Lean Sword, etc., came out to say, hey, this does not represent our position. So let's stick to the initial position.
Right.
The initial position states that the procedure so far has been good. They hope and pray that it will continue that way. Nobody else, nobody has come out again to say that there has been any other infringement. She has cited other infringements now, or alleged infringements. She cited the idea that the venue was hostile to us.
She said it brings back some traumatic memories
to her. Yes, my friend Solomon Owusu just said that he had traumatic experience at the High Court complex, but anytime he has case, it's the High Court complex he has to go. Okay, she had lawyers. She could have had that discussion with the lawyers to say, these are the issues. Can we try and get a better place? I believe that place was chosen because of security reasons the serenity. They will have considered a lot before choosing that place. Now, the idea that she brought in the traumatic experience that planning was done, etc., turned out to be false. So we can discard that. We can forgive her and discard that.
You say her historical accounts are not so accurate.
They are not accurate. Not so accurate. They are not accurate. Because we refer to the report on the murder of the judges and the military man. They are not accurate. And he said the military man was her uncle. They are not accurate at all.
Because that latter point you made, was that not her uncle?
That was her uncle.
Okay.
I mean, the report that planning was done at Edu Lodge was not accurate.
Right.
Because the murder, I think, occurred around June, July of 1982. The report says that Captain Kojo Chikata met Amate Kwe in September in front of Edu Lodge. So there couldn't have been the planning, there couldn't have been the murder before the planning. That could not have happened. So we can forgive her. We don't have to go into all those little webs, etc., and tie ourselves in something we can't come out. So we can forgive her. She talks about the fact that the husband is not allowed to accompany her. Now, the husband is not allowed by law. If she wants the husband to accompany her, then the husband could be recorded as one of her lawyers or one of the counsel that she needed in.
She says it's for moral support as she goes through this particular process. Is that a lot to ask?
Yes, it is a lot to ask. Because, you see, the framers of the Constitution had something in mind. That's why they said it should be done in camera. Now, if you wake up this morning to say, I'm going to give moral support to the suspended Chief Justice, is that too much to ask? Then we have 10 people from my village coming to say, we want to come and give her moral support. Is that too much to ask? Then we had 2,000 people massing up. I mean, that would be too much to ask.
Within the realms of reasonableness, maybe we make some provision for one person. Maybe she says even her children. Maybe her children can also come and be a part of the process. So maybe one has the husband, maybe one child can also attend.
There is a reason why it said in-camera hearing. It is not for her alone. It's for the office, to protect the sanctity and dignity of the office, to protect the panelists on the committee, to protect the witnesses, to protect all others who will give testimony before the committee. That is it. It has nothing to do with her. So she can leave that. I mean, when you put yourself in the line of something, you must play by the rules of that game. You don't say that I am here, so give me a different rule.
The rules are the rules.
The rules are the rules. You can't go with a different one. So that is why I'm saying that the infringements she's alleging are so small and so trivial that they cannot stand test of time in a lot of places. So we can forgive her and move on with that. Now, she has gone to the High Court to assert her human rights. Why won't she wait for that? So once that is determined, look, I wish I was so close to the suspended Chief Justice. I would have told her, it's always good to fight, to be brave. Chinua Achebe said it, but sometimes it's better to be a coward. Let some of these things go. I was really surprised, sad, when I saw her appeared in the Supreme Court herself. I don't know whether you saw the videos, the news item, when people were trying to take picture of her.
Indeed, she was descending and the cameras were all over.
I don't think you found that nice. I mean, and aside that, the part that I feel a bit sad is when you go to court, the clerk will mention your name. So the clerk of the Supreme Court, who used to tremble at the mention of her name, that the Chief Justice is coming, will now say, Her Ladyship, Justice Saki Tokonu. Then you will stand up. Then she will turn and say, Up my laws, applicant present. Then she will do sign for you to sit down. I mean, come on. That is not too bad, but how can you lower yourself to that level? Have some dignity. The one that you have, keep it intact. And I believe strongly, if steps had been taken behind the scene to have done some negotiation, by now maybe some good English would have been written from the presidency, would have all read it, and maybe she would have said, for the unity of the institution, etc., then I am going. Again, as someone will say, why is it that she does not trust the judiciary, which she was head of for all this while, and now she wants to go to ECOWAS Court of Justice? That will be our imagination. Assuming that she comes back, which I'm praying she does. Assuming she comes back.
Theophilus,
Yes.
That has piqued my interest. You're praying that she comes back in her capacity as active and acting Chief Justice.
No,
given everything.
Not as acting. She comes back as a Chief Justice.
Fully reinstated.
Yes. I am telling you that.
Theophilus, do you think I believe this particular
Watch
line
my
of...
lips. Watch my lips.
Right.
NDC has no interest in her removal. NDC as a party has no interest in her removal. None at all. None. We don't have any interest in her removal. People can give their own stories, etc. Presidents, when he was campaigning, said ABC, some which turned out to be false because they cut tapes and joined them. People can say they don't have any interest. Assuming she comes back, will she be able to work with those same people? There will be a very toxic environment because she has already taken some of them on. She has taken at least the committee members on, and she has gone to the same court, and her colleagues had ruled against her. How will she be able to work with them? The environment there will be toxic. And she has to empanel them. She can't be on every panel herself. She can't be 5. So I think that we have reached a stage where the Chief Justice should say, let me pause. It is now rainy season. Let me relax. Let me let go.
How do you assess the argument that the CJ has effectively been removed from office without a final judicial determination? You hear it from all different quarters. The CJ is a goner. I mean, this is just a matter of formality, almost as though it is a foregone conclusion. You talk about some of the tapes or clips you allege were, cut and pasted to support this sort of argument. How do you respond to these thoughts?
My response is that the law is the law. Let's allow the process to run its course. The CJ herself has just told us that her removal, which the Constitution allows the president to do, is as though she has been removed. Perhaps some things happen at the hearing that we are not aware of, and she has done an assessment to see that with these ones, I think that I look like I am gone. I believe that those who are saying that she's a goner are actually the people who were defending her in court and filing some of the processes. And I don't know what interest they have so much, because it is not the person, it's the institution. It is the office that we are talking about. Those who feel that she's a goner, perhaps they have sat down, analyzed few things to say, with what we are seeing, with her conduct, everything, we don't think she can even survive.
They predicate that argument on the fact that they say this has already been planned. These are machinations of the NDC already laid, before the president took office. But we can park it here on this particular conversation. It's one that we're keeping a keen eye out on, and I'm sure that as the days and weeks and months progress, we'll be getting to know more. So on this particular issue, Theophilus will park it here, and I want us to get into another very important topic, one that I know